Got an email from Tim Game. Please let the solicitor for the Northern Territory know that I will be invoicing for Mr. Game, Mr. Glass, Ms. Edwards, and Ms. Anderson.
He'll be what? He'll be what?
Invoicing for. Did you see that?
Yeah, I saw that.
Yeah. Morning.
Morning.
Good morning.
You look sleepy. Are you? No, just
No, I'm actually
well rested.
well rested, and then I did my tax, I settled a matter, and then I went to the gym. And so
Who
now
are
I'm
you?
just going to bliss out here and do absolutely nothing.
What's new, Patrick?
Well, what's new is that I've done my tax. That's it. Or did my best, whatever it is.
Are you doing
No, I'll do property.
That's just stage
Bye-bye.
one.
Yeah. Look, I suspect that we'll kind of, there's one thing I want to address, and then we'll just be like, and the informant is made available. Like,
I saw that.
haven't noticed. Yeah. Maybe it's us. We're all wandering around threatening people.
The lawyers.
Kate's got her first trial next week.
Sometimes I feel like she might give it to someone else last minute. This one's running. You say Kate?
Ballard.
Yeah.
Yeah. Never met anyone who is like so unfairly insecure about her legal
Yeah.
abilities because she has.
She asks everyone, is this right? Is this right? Is this right? And then,
You're like, yes.
yes.
Trust your judgment. You've
Yeah,
got great
yes,
judgment.
Yes, and then she'll go to someone else and they'll give the same answer. She used to be really funny at the firm. You could see her walking down the hall. She'd go to one office and then like she'd have a chat in the hall and then 10 minutes later you hear her having a conversation with someone else. Be like, don't go to everyone to do a ratio of how right.
Cannot wait until the end of next week.
I don't think we're going to sit all day for this. I think it'll be done by lunch.
Yeah, I think you're right.
Just sent you some subs. Can you just look at them? They're the
Ugh.
bail ones. I just need to look at it myself and change it to Andrew Boat rather than Nice Legal that they've got.
Yeah. For that same matter?
Yep.
You go, oh no, you're not, you're here until next week. You're not
The end of
going
next
on
week,
the
yeah.
Saturday flight, no. Hey. Yes, it is. Hi. Yeah, it's all good. Thank you so much. Perfect. Okay, thanks. Who didn't? What did you say, sorry, Julia?
Even Mel didn't know about the CBD shutdown, so I think.
Okay.
Can I interrupt you? Are you busy?
No.
I'll show you something. So,
Good morning, Ian.
Good morning.
Tim saying,
71.45. Good, thanks, mate.
Have you connected to Phil on your phone?
I think, yeah, it all depends on him.
You never know, I might take 2 hours, 3 hours.
Now, if I could just read to you from the letters patent to the...
That's right.
Ian's any longer than 15 minutes, I'm kicking him under the table. It's not a joke.
I love your Jeff O. That's so
You'll be
awesome. It's like so
posing
regal.
an improvised
It's meant to
fourth
sit
position.
A subtle.
Foundation, I know, because mine's has
That doesn't actually work.
work, yeah, mine's covered in it.
And it's meant to sit a bit more evenly,
Yeah,
so it doesn't ride up, but that doesn't always work either.
Some bits on them, or is that a special?
Yeah, it's just pretty.
A little bit like RBG.
yeah. RBG had, yeah, she had all those like,
So the reader package when I signed
yeah,
was the robes plus 3 jabots. So I
Yeah.
got 2 of these and 1 of those.
those, yeah. Felicity Fox always has, she gets hers made, there's an,
Just get that
oh,
signature.
sorry,
It's not fun as this conversation.
you want these submissions?
Oh, sorry, yes, of course.
Just slept for the last 12 hours. I can't get my sleep.
Yeah, it's
Well, you've been doing live crosses at 6:30 or something.
Yes, not this week, funnily enough. No one's interested in what's going on.
we know that. It's just a matter of how you communicate. How fascinating what's the principle you describe?
Yeah, breakfast television audience.
I think you're being defeated. No, this is fundamental stuff about rights and freedoms.
Yeah. As soon as you
Speak
put
more.
Just coming to you live from the Supreme Court, where the Attorney General has submitted that you have to read Section 38, Sub 1 in its immediate context. That context. No.
Would you like to do it, actually?
Have you got
Patrick, you just did
PowerPoint?
the words off screen and Mel just has to do it.
Yes, it's a lovely court, but having to get down under the table is really a bit silly.
Oh, no, just new inquest dates for inquest.
For
the domestic violence one.
No, actually.
something else.
Is that annoying you?
I do have a task for you. I have a task for you.
Oh, really? Is that annoying?
Didn't you ask me that a moment ago?
Yeah, but you didn't answer.
I did.
Oh, what did you say?
I said it wasn't. Thank you. Which part of this do you want to address?
Trick question and not answer.
Can you just remind me of the name of the case that talks about the authority of seriously considered dicta?
I think Blue
Not Project Blue Sky.
Bell talks about that.
Okay,
And
see if you
then
can find it for me.
it's picked up in
Okay, wherever it is. possibly. I will take your purse, your jewellery, your dignity, everything that's within reach.
I knew he was a hard taskmaster, but I didn't know he was a thief, Amanda.
Yeah, my time, my
Thorough
sanity.
instructions. Yeah, they're gone. Good morning. Oh dear. I think my advice to you is to stay here.
What does the rest of your year look like, Ian, once you finish with this, or
There is no finish with this.
never?
No, it's this all the way.
Yeah.
Yeah, we're going to try and get a bit of a start on submissions while they're all fresh in our minds, because those submissions are simpler than other people's. They're significantly derivative of what our two main witnesses are going to say.
Yeah.
So we're finishing the third affidavits for each of them, and that gives us a springboard into submissions, so we're going to make a start. Because the idea of starting to do submissions in March or
It's just, no.
when it's all gone stale would be on.
Are you heading back, or are you going to stay for a couple of weeks? And
Look, I'll go home, but I think Peggy and I will start writing our submissions, at least. I mean, there are some things that we'll never be able to resolve until Ralph gives evidence, but...
Plenty of other things you can.
Because, yeah, the idea of coming back to it.
Yeah, you go stale fast. That's the frightening thing.
Morning, Alice Springs.
Good morning. Can you see and hear us all right?
Yes, we can. Can you see the barcode on the bench?
Yeah.
Thank you.
Right, so the Teams link will be Teams at Teams. Yeah.
Thanks very much for saving my bacon last night. All right, I wouldn't have got in, would you? How'd your quiz not go? We won?
We won the quiz.
Ben? Ben Wild?
Yes.
Can you hear me? It's Paddy Coleridge. Would you mind stepping outside court and I'll give you a call?
Yeah, sure.
Ooh.
Yeah, one of the questions was who was Lawyer X, which was a case I acted on for 4.5 years. So, yeah, so that was an easy win. That question. There were quite a few on legal TV shows, which I was completely useless at.
Yeah, quite a lot of Tom Cruise themed bad movies from the 90s.
I like John Grisham novel.
Okay, yep,
Yeah.
so Darl.
Oh, did we get? Was it Pelican Reef?
Please enter the conference ID, followed by the pound or hash key.
135. Sorry, 106.
Please hold while I try to connect you.
I was going well with colouring my notes, and then I got onto a bit of a diatribe about the principle of yellow.
No.
That's bizarre.
That was a spoiler.
Might be 45 minutes.
Which I reckon's Ben.
Her Honour may encourage me to hurry up.
I was given a few signs yesterday.
When did you fly?
I'm not actually going till tomorrow
Oh,
morning.
yeah, okay.
I'll just do some work this afternoon.
Yeah. Go this afternoon if we finish.
Hey, Melton.
Oh,
Yesterday.
sweet.
Cameras, can you hear me all right?
And?
It's in.
Yes, I can hear you.
In the very last line of your submissions, you've got a reference to the police association. I think you may not have meant that.
It was my clumsiness.
That's all right. I just want you to be conscious that there's a difference between the Northern Territory Police Force and the association.
I have been made aware of that by those who expertly changed the submissions, and I've inefficiently picked up most but not all of those changes.
It's okay.
I do understand you're the entity established by Section 5 of the Police Administration Act.
Yes.
Rather than the union.
Correct.
Yes.
If I put two bit vision.
Just waiting.
What two bulletins speaking?
Oh, that's it.
Okay, no worries.
It's so sad. He's just such a lovely man. It's kind of pointed out.
I won't be doing Julian Murphy's been very flexible.
Yeah, and that's going to be my general. Goes to the high front. Yeah.
Flying to Canberra.
A little special leave application.
Done the papers, wouldn't it?
Honest, rather a mess of things. That was 3 and 16 now. Excuse me, Mr. Associate. I'll be referring in my orals.
Which bundle? Right, okay. Her Honour, she didn't want to bring the laptop down today because she didn't think she'd need it, but I'll go get it now.
We can work around it if she doesn't have
Sure.
it, otherwise, yeah.
I'm sure she'll be happy to get it. Yep.
It's just those two items.
Cool.
Sorry, I should have let you know earlier this morning.
No, that's fine.
I know, we were. Beth and I were high-fiving.
What's your prize?
We got $100 to spend at the salubrious hotel we attended, which someone else took off with, so.
The promise of a future lunch that
Yeah,
you won't be able to.
exactly, I know. I'll extract a beer from each of you next time I see you. There were some pretty obscure questions, you know. There are a few that no one got the answer to.
Just plucked from Steve Ledec's strange mind.
Right, yeah. I know, he was so bemused by the fact that no one knew the answer to some of those. What's wrong with you?
Silence all stand. This honourable court's now in session. Please be seated.
Madam Lee Bowens in the Territory Coroner.
Yes, now where are we up to? So it's Mr. Nekvapil, yes?
Well, in fact, earlier this morning, Dr. Freckleton and I had a change of heart, and so we're going to go in the other direction.
All right. Dr. Freckleton, yes? Yes.
Good, I was worried by the pause. Thank you. Your Honour, the issue being canvassed in these proceedings is extremely important for the viability of coronial proceedings in the Northern Territory. The Northern Territory Police Force has a particular interest in coronial proceedings, and we set that out in our submissions in respect of the appropriateness of being given intervenor status. But integral to the functioning of a coroner in the Territory is the involvement of the police, both insofar as they can be directed by the coroner in a variety of respects, and in relation to the role that they play in investigations in an ongoing way. It is in those circumstances that we advance brief submissions to you in respect of how Section 38 should be construed and how you ought to view the ongoing role of penalty privilege in coronial proceedings. The fundamental underpinning of what the police force says to you is that it is extremely important for coronial proceedings in the Territory that in the particular context of Section 38, penalty privilege should be regarded as having a comparable status to the privilege against self-incrimination, with the outcome that the coroner can direct a person in the prescribed circumstances to answer questions where it is expedient in the interests of justice, with the very significant protection that Section 38 provides.
In other words, you're adopting the construction that was contended for by the Attorney-General?
Yes, we are.
Right, thank you.
We'd just like to say a few things about how the complex matters in this case can perhaps be analysed in a straightforward way, Your Honour.
Thank you.
The privilege against self-incrimination and legal professional privilege are particular rights which are substantive common law rights. Daniels at 31, Frugnier at 39 say as much. We say that a straightforward analysis of the situation is provided by Justice Kirby in Rich at paragraph 129. Where referring to penalty privilege by contrast, he says that it is of a lower order of priority. It has a more recent and specialised origin and purpose in our law. It should not be blown into an importance that contradicts or diminishes the operation of the Act and the achievement of its purposes. That sets a context and establishes a contrast with the other two privileges, Your Honour. The next question is how you should view the authority of Daniels and Rich. We say that the analyses by the High Court judges ought not to be lightly disregarded. At the very least, they are seriously considered dicta and therefore of powerful authority as set out in the Farrer Constructions decision. Now, in our respectful submission, there are some things that you do not need to do. One is to determine whether penalty privilege applies in an inquest. The reason why we say that so straightforwardly is that the coroner disavowed making such a decision at paragraph 32 of her decision.
And further, is it not so that if you're correct and the Attorney-General is correct about the interpretation of Section 38, it just doesn't matter?
That's right.
The effect of Section 30, it doesn't matter whether the effect of Section 38 is to confer a limited form of penalty privilege or whether it is to abrogate in part to a limited extent an existing privilege. The effect is just the same.
The outcome is the same. That is so, Your Honour.
All right.
Now, pursuing this distinction between legal professional privilege and the privilege against self-incrimination and penalty privilege on the other, it is significant in terms of any ongoing existence of a common law right of penalty privilege by reference to the principle of legality which had its origins in Potter and Minahan. Certainly, while the privilege against self-incrimination and legal professional privilege can only be abrogated by clear words or necessary implication, the same requirement does not apply to penalty privilege given its lesser status. What that means is that if Your Honour has any concerns about the specificity of what is stated in Section 38, that should not trouble Your Honour in terms of abrogation. What we say to Your Honour is that you should look to the nature and purpose of coronial proceedings and the coronial legislation in the Territory. Coronial proceedings are unique under our legal system. They are a mechanism by which a judicial officer is able to make findings and, relevantly to the case before you, recommendations and comments as to the circumstances and cause of death. That has the public benefit of clarifying the record which is available for the community about matters which may be causing public consternation and may be the source of ongoing risk to the community. It is orthodox, of course, to describe coronial proceedings as inquisitorial rather than adversarial, and one of their characteristics, as seen in Section 39, is that a coroner is not bound by the rules of evidence and may be informed and conduct an inquest in a manner as the coroner reasonably thinks fit. The straightforward point that we make in this regard is that there is a high public purpose in enabling and ensuring that coronial proceedings accomplish their objective of finding facts and enabling recommendations and comments in the interest of public safety and the administration of justice. Now, it is uncontentious that Section 38 partially abrogates the privilege against self-incrimination, but that abrogation is qualified. The abrogation is by reference to the concept of crimination by virtue of the 2002 amendments, but there remains a major discretionary assessment to be made by the coroner, whether on any given occasion it is expedient for the purposes of justice that a person be compelled to answer a question. This is a real discretion to be exercised by the coroner. It may not be expedient where the consequences to the person of whom the question is asked may be of a very high order, for instance, if murder charges may be contemplated, or where the evidence can be obtained by an alternative non-coercive means. So the question for Your Honour is whether crimination incorporates penalty privilege. The finding by the learned coroner at her paragraph 35 is that Section 38 also partially abrogates penalty privilege, for the relevant purposes there not being a meaningful distinction between the privilege against self-incrimination and penalty privilege. At her paragraph 36, the coroner has tracked through the association between the concept of crimination and penalty privilege by reference to a series of 19th century authorities. We respectfully submit that she was right to do so and correct to find the alignment for the purposes of Section 38 between the two privileges. Now, the proper approach to the issue of statutory construction in order to determine whether crimination incorporates penalty privilege as well as the privilege against self-incrimination is relatively non-controversial. Should be done by reference to the Project Blue Sky principles, particularly those set out at paragraphs 69 to 71 by Justices McHugh, Gummo, Kirby and Hayne. That means that the first focus for Your Honour's attention should be on the words utilised. Relevant in that regard is the uptake of the word crimination and the failure to utilise, the cessation of utilising the word incrimination. That suggests that the purpose of that the reach of Section 38 is such as to incorporate penalty privilege as well as the privilege against self-incrimination. But it is appropriate also for Your Honour to have regard to the context of the provision, the purposes of it, and the general statutory context. So much is said by Project Blue Sky and many other High Court and other authorities, and that is buttressed in terms of the purposive issue by Section 62A of the Interpretation Act of 1978. In order for Your Honour to determine the purpose of Section 38, Your Honour is entitled first to have close regard to the words of the legislation and how they function within the Act. In other words, to assist the coroner to obtain as much information as possible by offering particular protection to alleviate the threat to witnesses' rights in Section 38, and also for Your Honour to have regard to extrinsic aids. Now, Your Honour has been addressed already, and Your Honour will hear more from our learned friend, Mr. Neckverpill, about the processes by which Section 38 came into being in 2002. But it is already apparent in our respectful submission from what has been placed before you, that the Northern Territory Law Reform Committee made plain, unsurprisingly, that the purpose of the Section 38 amendment was to enable coroners to get to the truth and to put barriers in the way of obstructions to such an outcome. For the truth to be arrived at by a coroner, they need to be able to receive as much evidence as possible from doctors, from correctional officers, from paramedics, and relevantly, from police officers. Section 38 enables a wide array of evidence to be received, although it might expose persons to criminal penalty. And the compromise adopted by the legislature is to preclude usage of the words employed, but to preclude the evidence being used against the witness in evidence in criminal or civil proceedings, or in proceedings before a tribunal or person exercising powers and functions in a judicial manner. And that's in Section 38(3), of course. That is a very broad protection in terms of direct usage of the incriminating material. It's a significant encroachment on people's civil liberties, but it is provided for in order to achieve a socially desirable objective, namely that coroners be enabled to assemble, as part of their investigation as an inquisitorial court, as much relevant information as possible so as to achieve their objectives. So in the context of all of that, the question is whether penalty privilege should be treated in the same way, it being a common law right, which is variously described, consistently valued, and important for the operation of our court system generally. What is urged upon you by the plaintiffs is that the privilege against self-incrimination is abrogated, but effectively penalty privilege remains. The consequence of that, as pointed out in Pineboard, Daniels, Frucnier, and elsewhere, would be quite extraordinary. Whether one uses emotive words such as bizarre, irrational, or absurd doesn't matter. The outcome would be that a person could be compelled to give evidence, although it would incriminate them, albeit that their words could not be used in future against them, but they could not be compelled if their words would be prejudicial for their interests in civil proceedings or disciplinary proceedings. Now, the problem there is manifest. In virtually any situation where a person might be in jeopardy of criminal proceedings, if they're employed as correctional officers or paramedics or police are, the same conduct would almost inevitably give rise to disciplinary proceedings. And so if the plaintiffs are correct, the effect of Section 38 would be completely undermined, and by a lateral application of penalty privilege, they would be able to decline to give evidence altogether. We say, to use a neutral word, that would be anomalous. It would also appear to be inconsistent with the intention of the 2002 amendments, and it would constitute a major impediment to the efficacy of coronial investigations. Therefore, by reference to the words used, the history of the term criminate, the overall structure of the legislation, and the purpose of Section 38 as amended, we say to Your Honour that Section 38 should be interpreted in such a way as to enable coroners to undertake their important investigative duties in an effective way. The outcome of our submissions, therefore, Your Honour, is to join with the Attorney-General to urge Your Honour to decline the applications for declarations and to uphold the orders made by, or the ruling made by the learned coroner.
I don't think that that's something I can do, that it just stands. It's simply declining to make the declarations, I think, isn't it?
Yes, it is. Your Honour's orders with respect should be simply to decline the declaratory relief sought.
Yes, thank you for that. Thank you. Right, Mr. Neckville, yes?
Yes, thank you, Your Honour. Now, Your Honour, like our learned friends for the second plaintiff, we would start with the Coroner's Act as enacted in 1993 and then move to the amending Act. I'm very grateful to your associate for what I anticipate he's about to hand to you, which is...
He's very efficient.
He's very efficient. 2 tabs from our rather longer bundle. The first being, I hope, tab 3, which is the Coroner's Act as enacted.
Yes.
And the second being an English case that I'll come to a bit later in my submissions.
All right. So the Coroner's Act as enacted is an annexure to one of your affidavits?
No, we provided a bundle of...
just documents. All right.
Of cases.
I just wanted to keep, that's
yeah.
good. I just wanted to keep track of what annexures, like people annexed all sorts of things to affidavits, and I just wanted to keep track of which ones were actually going into evidence. Well, that's all right.
Well, it's probably just important for me to mention in that regard, Your Honour, that in folder 4 of our folder of authorities,
yes,
we did include a number of reports from the Royal Commission, reports of the Northern Territory Office of Aboriginal Affairs and other things. I found them on the very useful Northern Territory Parliamentary Papers website as tabled papers.
Yes.
And I'd taken the view, but it may be inapplicable in this jurisdiction, that because Section 63B of the Interpretation Act expressly says that regard may be had to extrinsic materials, including relevant Royal Commission reports, that those would be able to be put in as extrinsic materials without needing to annex them to an affidavit?
Yes, I'm not taking issue with that.
Yes.
I'm more or less taking issue with the
volume
of material that was annexed to affidavits. And I've already said I'm not accepting that in evidence unless they have been explicitly referred to and my associate's keeping track of the ones that are in. Everything else is out. But I should just say in relation, that's not an affidavit, but in relation to that voluminous material, I am not going to read or take into account anything that hasn't been expressly referred to in submissions.
Yes. And exactly what we would ask Your Honour to do with respect is to have regard to, I think it's part C of our written submissions, where we set out at some length the quotes and references to those reports to which we invite Your Honour to have regard. And unless a matter is referred to in our written submissions, either in the body or in a footnote, we don't ask Your Honour to have regard to anything else.
Right, thank you very much for that indication, because that's exactly how I intend to proceed.
Yes, thank you. And further to Your Honour's indication of yesterday, today I don't seek to tediously take Your Honour through even our written submissions on that.
Oh, you can take it. I have read those written submissions and, well, yes, I have.
Thank you, Your Honour. So it's only those 2 documents in the folder which I propose to take Your Honour to in oral submissions, as well as very briefly some of the cases that were already referred to yesterday.
Yes.
So could Your Honour turn then to section 38 in the Act as enacted?
Yes.
And conveniently, 38 and 41 are all on the same page, page 16. And
not in this version.
It's
all right. It's on page 17, but I can...
No, it's coming, Your Honour. I think it's...
I can follow it along in here. Does it have to?
As long as it's the pre-amended version of sections 38 and 41.
No, it's not.
I know Your Honour knows what's in them, but we do focus heavily on the position at this time because it's important to our argument. So,
yes.
So section 38, a person shall not under this act be compelled
Yes.
to answer a question that may tend to incriminate. Section 41(1)(c), a coroner may order a witness to take an oath or affirmation or to answer questions. And subsection 3, a person shall obey a summons, order or direction under subsection 1. And we say there are relevantly 3 constructional choices. First, penalty privilege was protected by section 38. If that's the case, it was later abrogated by, or partially abrogated, as we've been saying, by the amending act, by the certificate regime in the substituted section 38. The second possible constructional choice is that penalty privilege in 1993 was protected by a presumption or implication. That is, even though the act was silent, Parliament should be taken to have intended that the penalty privilege was protected. And in that case, we'd submit, for reasons explained by the Attorney-General and more briefly Dr Freckleton, for the police force, it was later abrogated, picked up, if you like, expressed and abrogated by section 38 as substituted in the amending act. But the third constructional choice, and the one for which we contend primarily, is that penalty privilege was never protected in the first place. And we submit that in that case, penalty privilege simply wasn't touched by the amending act. Now, obviously enough, Your Honour, which of those 3 constructions is to be preferred is a question of statutory construction, and we rely on text, context and purpose, as well as relevantly the principle of consistency with international law.
So on your interpretation,
yes,
I suppose also, as in the plaintiff's interpretation, the change of wording from incriminate to criminate was just a random accident. It had no real purpose. Just a random choice.
If our constructional choice at 1993 is correct, yes. If that third choice is correct, then incriminate to criminate didn't matter. It just meant self-incriminate.
Yes.
If it's the second choice, then we say the changes both to incriminate to criminate in subsection 1 and also subsection 3 with its reference to civil proceedings and tribunal proceedings, etc., should be taken to pick up and deal with penalty privilege. But Your Honour is quite right.
On your first, your preferred interpretation, it's just an accident, doesn't mean anything.
It may have been modelled, as you were told yesterday, on the WA provision, but it didn't relevantly. And where I'll come to is we say there's no discernible object, purpose, intention by Parliament, which would explain a decision to move from members of the police force just have to answer questions, regardless of whether they might be disciplined, to suddenly after 2002, members of the police force can obtain a certificate, which means relevantly that they might give all sorts of evidence under oath, which is then in the public domain because it's an important principle in the Act that these things are done in public. A report's tabled in Parliament. The conduct of the police officers may arise entirely from their oral testimony. And then you have what we would submit is an untenable situation where the coroner has made findings and recommendations concerning the conduct of this police officer. the whole function of those recommendations is to ensure similar things don't happen again. Let's say the coroner might make a single recommendation, this person should be removed from the police force, and yet the commissioner can't do anything about it because the member just produces a certificate.
That's really not the case, is it? It's only direct use that's protected under section 38(3 if the Attorney General construction is correct. The whole idea of being able to look at like a line of inquiry, getting other evidence as a result of the answer having been given, that's not precluded, is it? You know, it's not just that. You don't look at that answer in isolation, do you? You look at all of the evidence that will have come out of the coronial inquest, and you can say, well, that is not able to be used as an admission against that particular, so that particular answer cannot be used as an admission against that particular police officer. But all of this evidence may well lead to, further investigation or what have you, and exactly the result that you have said can't be arrived at, could be arrived at.
It may be in some cases that the evidence is objective evidence in documents from camera footage these days, but although in 1993 it would have been a bit different, etc. But there will also be cases, which is where this will become most acute, where the only person who knows what happened is the police officer.
Yes.
And their oral testimony will be the account of what happened. And, Your Honour, dealing only with the third construction, what we're talking about is the lack of any indication with the amending act of a move from the police officer just needing to answer the questions and having no protection to suddenly having such a protection, which would introduce this incongruity. So if we were starting from a blank slate, that may not be as persuasive, but it's the notion that one would move from no protection to a protection introducing that incongruity, which we rely on.
Yes, I do follow the point.
Thank you, Your Honour. So, Your Honour, I think even though it's dealt with at the end of it in the structure of our written submissions, it's probably best for me to just begin with the principle of legality, because that's really what our learned friends for the plaintiffs rely on most directly.
The Attorney General has made submissions about that and taken me to the relevant parts in those particular cases, which would seem to indicate fairly clearly that, that if, one follows Daniels and Rich, that penalty privilege has a lesser status and does not, the principle of legality simply doesn't apply. It's just normal statutory construction principles.
Yes.
And I think that's been pretty well covered both by counsel for the Attorney General and by Dr. Freckleton.
Yes. And I certainly don't wish to revisit any of that or those cases.
Yes.
I do just want to make a point about the development of the principle.
Yes.
Because I think it in a sense, explains why there's an apparent incongruity between Daniels and Pine Board, which in fact is not an incongruity at all.
Okay.
So, and if I pontificate for 15 minutes and it's of no assistance, then Your Honour.
No, please don't. I wasn't attempting to cut you off.
Now,
hang on. You're saying there's no incongruity between Pine Board and Daniels?
When one understands the development of the principle of legality.
Okay.
Because the point that we wish to make is that when Your Honour comes to construe the Coroners Act in 1993, you'll apply the common law principles of interpretation as we understand them today. Mm. And as we know, even with the general principles, there's a sort of oscillation from Project Blue Sky, Alcan, things move back and forth a bit. But with the principle of legality, it has distinctly evolved It's been traced in judgments and learned articles, but I can summarise it by saying that the modern re-emergence of the principle of legality began with the Mason Court in about 1987 in Re Bolton Ex Parte Bean, 1987 162 CLR 514, and developing over roughly a 7-year period to Coco and the Queen in 1994 179 CLR 427. And so the point I want to make is that the earliest of those cases, Re Bolton, was decided 5 years after Pine Board. And that needs to be borne in mind when it comes to the reference in Pine Board at page 341. I don't need to take your honour there. Mr Doyle took your honour to it yesterday. There's a reference to Professor Pearce's then very recent second edition of Statutory Interpretation in Australia, which discussed a principle concerning common law rights. But at that stage, the principle of legality had not yet developed either in the strength of the principle, the irresistible clearness type notion, which took hold from about 1987, by reference to Potter and Minahan.
So you said that the criticism in Daniels that the plurality in Pine Board didn't, take account of Potter and Minahan was a bit ripe, given that it had not been decided at the time.
That is exactly where I was coming to. It was an anachronism, because what both the plurality and Justice Brennan were doing was just applying the normal principles of statutory interpretation, into which mix text, context, purpose, common law rights. It just went into the mix. But then with the Mason Court and through to the French Court, you got this monolithic, irresistible clearness principle. But the corollary of that, which you see in Daniels, is it's just going to break statutes if you have such a binary principle and then you include every common law right.
Yes.
There's so many weird, weak...
As you say, with the development of the principle of legality, there was a sort of necessary shrinkage of the kinds of rights that it applies to.
Exactly. And so then it was confined to the class of fundamental substantive common law rights and freedoms,
Yes.
which is why in Daniels they reinterpreted Pine Board. So in fact, even though their honours, with respect, were critical of Justice Brennan for not referring to Potter and Minahan, Potter and Minahan hadn't been dug back out of Maxwell on statutes until 5 years later. So really there was never a point where my learned friend Mr Doyle's proposition at page 13 of the transcript, that the High Court has recognised penalty privilege to be a distinct privilege attracting the principle of legality, that's never been the case. It actually was, first of all, the weaker principle, then, and what's happened since in our submission, if I could just take your honour to do this in a brief way to our written submissions, which I'll just have to find as well.
This one?
And it's at page 18 of our written submissions, where we deal with the principle of legality.
Yes.
And we've quoted here from a decision of Justice Edelman, Deputy Commissioner of Taxation and She, which is very recent. And His Honour footnotes a couple of cases, including at most 3 judges, one of which was him. So I can't say this is a universal position, but it does represent, since the zenith of the principle of legality in about 2010, 2011, 2012 with the French court, a refinement and, I'd say, a more nuanced approach to it in recent times. And what His Honour said, it's not a binary rule of interpretation. It's based upon basic common expectations of justice, that the more that an interpretation would result in impairments of rights or freedoms, and the more fundamental those rights or freedoms, the less likely it is that Parliament could have intended such a consequence. It's much more nuanced.
Yes.
And in fact, that's the sort of exercise I think I'd submit Justice Brennan was attempting, and the plurality was attempting in Pine Board, because they hadn't encountered this binary principle yet. And you see it again in paragraph 63 in R and, should be R, quotes R, it was an unfortunate pseudonym, an independent broad-based anti-corruption commissioner, where the plurality in that case, and it was about there was this attempt to extend what's known as the companion principle, that you shouldn't be compulsorily examining people when they might be charged, to circumstances where there was no hint of a charge. And so if you like, it was partly the case was dealt with on the basis that you couldn't extend it that far, but if you like, it was an example of a weaker principle, like penalty privilege. And what their honours said is, the appellants in that case, proposed construction would deny the IBAC, but we say the coroner, access to precisely the kind of information about matters of grave public interest that may bear upon the discharge of its functions from the very people who are likely to have that information and who may be the only people who do. This would tend to frustrate the statutory objective.
But Section 38 doesn't do that, does it? Section 38 enables the coroner, if it is important in that respect, to obtain that information with a certificate.
And Section 38 is convenient if one takes the compilation as it today. But the reason we start in 1993 is we say that Your Honour first needs to decide, did penalty privilege exist? Was it recognised at a time where the certificate didn't provide a convenient answer? And if Your Honour says, no, it didn't, which we would urge on Your Honour, then, and we'll come to this in a moment, when you get to the amending act, the mischief just doesn't touch it. And therefore, all Section 38 does is provide a nuanced discretionary abrogation of self-incrimination privilege, but penalty privilege just goes on being irrelevant.
Say that again, just because I was kind of following the first part of your argument in my head while you were saying the second part. So if Section 38, as originally enacted, did not apply to penalty privilege.
And if penalty privilege was not otherwise an excuse by presumption/implication, however you want to put it, if it wasn't silently an excuse, impliedly an excuse, then, and I will come to this, when you get to the amending act, it just doesn't touch the position, because the mischief, which is the coroner being prevented from getting at the truth, just never engages with penalty privilege.
So the amending act doesn't address the mischief that in the, identified in the second reading speech and the report of the Law Reform Committee.
We say it does address the mischief because it changes Section 38 and self-incrimination privilege.
But it doesn't address the mischief in relation to, there
is no mischief for penalty privilege.
Yeah.
Because it never got in the way of the truth. Because it was never available.
Wait a minute. Yep.
So that if...
Well, but... And yet the second reading speech and the Law Reform Committee report actually appears to be directed directly to the penalty privilege situations. People who were refusing to answer, not because of self-incrimination, but because they feared consequences in either civil proceedings or disciplinary proceedings.
Yes. Now, what we say about that is when Your Honour looks at the second reading speech, the example given was the two men with a woman's body in the riverbed who refused on self-incrimination.
Yes.
That was the example given.
Yes.
And that obviously formed part of the mischief.
Yes.
Right? But then they refer to medical practitioners.
Yes.
It may be that Mr. Austin ACKC, when he spoke to Mr. Kavanagh at the Parup Saturday market, might have speculated about medical practitioners. It may even be that a clever lawyer had taken a point for a medical practitioner and it had been accepted. But as a matter of law, we say, applying the common law as understood now, we would say, Your Honour, would construe the Act from 1993 as not protecting penalty privilege. And if Parliament enacts something on a mistaken understanding, and the Attorney-General's submissions give Your Honour some authorities on this, the mistake can't somehow metamorphosise into the law.
No.
And so we would say that the object of the amending Act was still achieved because...
In relation to self-incrimination.
In relation to every legally available excuse, which was self-incrimination, because penalty privilege was never available at all. So it got rid of self-incrimination, which was available. Penalty privilege never was available, and therefore it achieved its object.
But if the mistake was an assumption that penalty privilege was available when it wasn't, then it still may have been the legislative intention to abrogate that to a limited extent in section 38, in which case the actual effect, given that, you know, the mistake can't metamorphose into the law, the actual effect would have been to both confer and abrogate, if you like. So confer a qualified penalty privilege. They might have thought that they were abrogating partially an existing privilege that wasn't there, but the effect then may have been, well, to confer a qualified penalty privilege.
We say the conferral would be exactly picking up the mistake. So that the conferral, if there was one, was on the mistaken assumption that it existed.
Yes.
And we say that because, of course, we're not looking at the subjective intention of the drafter.
No.
And so looking at it objectively, one has to, in a sense, perhaps wrongly assume that Parliament understood the effect of the law. And one can't look, and this is in Bell, but I don't need to take Your Honour there because Your Honour knows it, one can't look at the second reading speech and extrinsic material to detect the text of the Act,
no,
but only for the mischief.
Yes.
Now, the mischief was to remove every legally available.
Yes.
And we say it wasn't legally available, and
yes,
therefore it wasn't engaged.
I'm not sure that actually follows. If the mischief was to remove, if the mischief was legally available privileges that they wished to partially abrogate, and they thought that, you know, there was a mistaken assumption on the part of whoever that penalty privilege was one of them, if they enacted a provision which on its proper construction did refer to penalty privilege, then that's what it says. Doesn't matter that it was based on a mistaken assumption as to the state of the existing law, does it? If So supposing it explicitly referred to penalty privilege, then
I
that's
accept
what
that.
it means.
I accept
And,
that.
okay, then you go to the next step. If it impliedly refers to penalty privilege on its proper construction, same thing.
I accept that as well, Your Honour, but what we say is the only way of moving from a pre-amendment section 38, which only dealt with self-incrimination, to a post-amendment section 38, which impliedly conferred penalty.
A limited form of,
A limited form,
or qualified form of penalty
qualified
privilege.
with a certificate form
Yep.
of penalty privilege, is to do what's impermissible, which is to look into the second reading speech and say, aha, they mistakenly thought that there was a legally available penalty privilege.
Is that the only way, or can't you, I mean, because if you're construing the words of section 38 in the whole context of just talk about the context of the whole section, then the use of the word, instead of, the use of the word criminate instead of incriminate, and the extended range of bodies in which the protection applies in section 38(3 are textual indicators, are they not, from which you could imply an intention to include penalty privilege within section 38(1 without going to the second reading speech.
We would say, and here in a funny sort of way we join a bit with Constable Rolfe, is we would say that without some purpose, without some identifiable object, you wouldn't read the shift from incriminate to criminate as, in effect, providing additional protection to police officers. You wouldn't read, because it's not an obvious textual indication, you wouldn't, the subsection 3 doesn't, for reasons identified by Mr. Doyle yesterday, precisely correspond.
No, it doesn't, but they're textual indicators, are they not?
Well, only because Your Honour knows about the second reading speech and the Law Reform Commission, and therefore one is tempted to say, aha, well, I know what they thought and I'm trying to find it in the text. But if Your Honour looks at what Parliament should be taken to have understood, it should be taken to have understood, if our construction pre-then is accepted, that penalty privilege didn't apply, and there's no ascertainable object as to why they would want to protect police officers who may have done the wrong thing, who it may be in the public interest as manifested in the Police Administration Act for those persons to be sanctioned, to have some protection that they didn't have before.
Well, isn't there, I mean, firstly, it doesn't just apply to police officers, does it? It applies to everybody. And secondly, if you're looking at the position of police officers only, then there may well be a thought that, look, the police officers are pretty much obliged to answer everything under the Police Administration Act. So what, you know, you don't need to preserve that position in the Coroner's Act in order to have police officers subject to discipline, because there it is, you know, there are all of those provisions that are in, I think, the Attorney General's written submissions, or in somebody's written submissions anyway, that point out that really police officers have very little protection against self-incrimination, if you like, because of those provisions of the Police Administration Act.
That's true once one gets to the Police Administration Act. The difficulty is the step. I understand there's no derivative use immunity, but if I'm sorry, if I can come back one step, that they referred in the second reading speech, which we say I shouldn't look at, in effect, if our third construction is correct, to medical practitioners. There's no indication that police officers were actually taking such a privilege. It is different for police officers because coming out of the Royal Commission, the fundamental recommendations concerned a death in the custody or control of a police officer or from injury in the custody or control of a police officer. And when one looks at Section 76, which had equivalently very broad matters at the time the Coroners Act was enacted in 1993, the proposition at that time that a police officer could simply refuse to answer a question on the basis that, for example, it might show negligence or any of those very broad matters in 76,
Yes.
would have fundamentally undermined the duty of the coroner under sections 15, 1A and B and 26, 1 and 2, so that at that time we say the text and purpose speak powerfully against recognising it. And we say that then, if that's the position, then one really can't identify any purpose that is consistent either with the articulated mischief for the amending Act or the overall purpose and object of the Coroners Act for introducing a protection whereby a police officer can even claim a certificate.
That makes some logical sense if this provision were directed specifically to police officers, but it's not. It's directed to witnesses, and obviously the second reading speech that I'm not supposed to look at includes, has direct reference to medical practitioners and that sort of thing. Then it may be that there was at least a perceived mischief.
When one looks at the second reading speech one shouldn't look at, one sees that the only reason for referring to that was an understanding that that was a legally available claim. So that the only object, even on the subjective intent of the drafter, is to get at the truth. There is no clue anywhere of an object of providing an additional protection which wasn't currently available. It is necessary now.
So, okay, so there's no indication of an additional object to provide protection that was not then available.
That was not previously available. And it's important to look at police officers.
Well, that's right, isn't it?
Because it's a convenient argument to say, oh, look, it's got to be everyone. But police officers are engaged in a very different way. Because of the primary object of the 1993 Act, which is to get to the truth of why people were dying in custody.
Yeah.
And so to adopt a construction on the basis of medical practitioners, which then has the effect of excluding police officers, is really the tail wagging the dog. In our respectful submission, as at 1993, and applying that more nuanced approach stated by Justice Edelman, one would say a claim that I don't have to answer this question because I'm a police member and it will fall in section 76 does fall within the general rubric. C. Morris, which was also 2 years before the development of the principle of legality. It does raise that sort of common law privilege spectre. And I can have regard to the fact that it's on oath, but the fact that the coroner's not entirely judicial, it's not adversarial. All those things can go in the mix. But then when I look at the object, which is to have a brand new act, which will get at the truth, make recommendations, and these are express recommendations of the Royal Commission, which, as we've set out in our written submissions, are the precise and primary object of Section 26, make recommendations to the executive, to the responsible minister, who will then take action to ensure these things don't happen again. The proposition that a police officer could just refuse to answer on the basis that this will fall in Section 76 just doesn't work. And when one comes to the amending act, it's just in our submission not at all clear why, not that it's not clear, it might have said so. It might have said, we think police officers need more protection. But it's not, without that, and having regard to the objects of both the Coroners Act and the Police Administration Act, both of which surely would want the coroner to be able to get to the bottom of things and the police officer to be in the exercise of the protective jurisdiction. It's not a penal jurisdiction, it's a protective jurisdiction under Part 4 of the Police Administration Act. It's coherent to the objects of both acts that you would continue with there being no penalty privilege, that the police officers answer the questions in the coronial inquest so the coroner can get to the bottom of it and make recommendations. And then if as a result of those recommendations, or if just because the commissioner looks at the evidence in the inquest and says, we can't have this person continue in the police force, they can then use that material. So perhaps if I can, I've become quite excitable there, Your Honour, and perhaps if I can go back to my speaking notes and just see where I'm up to, but I've probably covered most of it.
That's your strongest point, though, isn't it? And that is that the object, the second reading speeches and what have you, the extrinsic material available for both, well, for the 1993 Act, very clear, get at the truth, particularly in relation to deaths in custody. And then it's in the 2002 amendments, the extrinsic material, pointing to a need to get at the truth, to remove impediments to obtaining evidence, and not a hint of an indication of that there being an additional objective to provide a protection that was not previously there to, well, police officers or any witnesses really who might be subject to disciplinary proceedings, like a doctor being struck off or whatever.
Exactly. Yeah. Perhaps I better just address the last part of my speaking notes, Your Honour, because
Yes, of course.
I do just want to go through, so, in a sense, revisiting those constructional choices of the act as enacted. If Your Honour accepts that the Coroners Act never did excuse a member of the police force from compliance with Section 41 subsection 3, and Your Honour focuses on Section 41 subsection 3.
Except to the extent conferred by
Section 38,
Section 38
yes.
as originally enacted.
Yes, there was no implied carve-out for the penalty privilege. There's no basis in the rules of statutory interpretation for, by the addition of subject to Section 38 in 41(1)(c), to construe it as now providing the additional protection.
No, that wouldn't go to, no, but it's the words of section, the Attorney General relies on the words or the text of Section 38 itself.
Yes. The Attorney General, with respect to our learned friends, starts from the Act as it today and says, well, look at this, it all makes sense. And he looks at the amending Act, yes. But we say that really, I suppose our argument points out that unless you've worked out what existed beforehand, you may not get there. And so what we say is that Excuse me, Your Honour. So yeah, just returning to where I started, if the court were to conclude that before the amendment, penalty privilege was, by implication, silently excluded, then one would engage.
You mean by implication in section 38 as it was originally enacted? In other words, that tend to incriminate would be construed so broadly as to include penalty privilege as well.
Yes, either that or even silently by the operation of... Your Honour's heard this debate about does one have to start with the act and imply it in or... But in our submission, because of once one understands the development, it's really the same exercise, it's just semantics. Because once the common law right's just in the mix, you're doing an exercise of construction.
Yes.
You just look at the text, context and purpose with the common law right in the mix, and it doesn't really matter whether you start with the right or start with the text. You're doing the same exercise. If on that exercise you would say either it's in section 38, then it's obviously been amended. But even if you said somewhere else in the Act by an implication from this common law right into 41.3, for example, which is in effect what our learned friends for Constable Rolfe contend for, that it was in there by operation of the principle of legality, then we say the amendments in 2002 would pick it up and partially abrogate it by the certificate, because then it does form part of the mischief. It is, as a matter of law, getting in the way. So that whether it's expressly in section 38 beforehand, or whether it's implied into the fabric of the Act by reference to the common law right, the mischief to which the amending Act is directed picks it up into section 38.
Yes.
It's only on our third construction, if it doesn't do that, that there's a mistake and it never gets engaged. So that's the critical point where we depart from our learned friends for the second plaintiff.
Yes.
Is that we say their construction must fail for the reasons the Attorney General's pointed out.
Yes.
But on ours, you never get there.
Yes. I'm still trying to exercise my mind around the concept that well, assuming there was a mistake, if the text by implication, if you can imply into the text without, if in context, the text of section 38 appears to pick up penalty privilege, then it does. And the fact that it might have been enacted on a mistaken assumption that penalty privilege was available beforehand, well, is neither here nor there, is it?
We would agree with what Your Honour said a bit earlier, that, and starting at the easiest proposition, if it's express,
yes.
If it says this includes incrimination and
penalty privilege, then we're in, yes.
We're in. I suppose really it's not that I quibble with Your Honour's proposition, but it's what Your Honour means by if it appears. And we say that there's no purpose. Your Honour's understood that point.
I have.
We say the text is not clear. The use of criminate as opposed to incriminate hardly expresses it clearly. Subsection 3...
Section 3 is a bit more of a problem, isn't it?
Well, we say it's actually, and our learned friend for Constable Rolfe pointed this out to Your Honour, it is actually a not uncommon drafting technique to provide a certificate for self-incrimination, which then means the evidence can't be used in civil proceedings or other tribunals. And there are at least two ways you can understand that. One is that, in effect, the evidence which is incriminating just should be cordoned off and can't be used against you in any of those forums. The second is that if it could be used, it could in effect be recycled into a direct use. That is, let's say one makes a confession in the coronial inquest and then you're sued, say it's a doctor.
Yes.
They say, yes, actually, I wasn't paying attention.
Yes.
And then they're sued in a civil proceeding.
Yes.
And the evidence comes out again, then the DPP can just pick up the evidence as used in the civil proceeding and prosecute on it. So
it has a purpose,
it has a purpose, yeah.
even if it only refers to criminal matters.
Yes. It in effect provides you a protection that's not so fragile that the moment you get out and someone sues you, you lose it.
Yes, I see.
And that's, I think, the effect of the submissions that Mr Doyle was making, showing Your Honour some of those other ones in Appendix B, I think it was. So if subsection 1 said something more express, and if subsection 3 was tailored to, for example, disciplinary proceedings or somehow a clearer indication wasn't proving too much to pick up our friend's submission, then Your Honour might say, even though I can't see any purpose for it, perhaps
Well, the text speaks with it, there's an implication in the text and that's it.
That's it.
And it may have been based on a mistaken assumption as to the availability of a, privilege before, but that's too bad. It's there. It's in the text.
It may have been discussions with the police association and they said, I mean, these things can happen. They said, well, actually, while you're at it, why don't you provide us a protection, and Parliament can do that.
Yes.
But there's no indication. That's
No.
Working out what should Parliament be taken to have intended. It's just, there's a sole object, which is getting at the truth. And that's
I follow
not certain.
that. Yes.
Your Honour, I do also have, and I just want to take Your Honour to that one case that's still in the folder. This is on the international law.
I don't think I have it. It's not in. Oh, no.
Perhaps I could just give Your Honour some references.
Yes, please.
If Your Honour,
if you can give me the citation and then the references.
I'll just put it in context with our written submissions, if I could.
Yes, where am I looking?
It's at page 15, and at paragraph 49, we've set out that the purpose, which we derive from the Royal Commission into Aboriginal Deaths in Custody, is also supported by the principle that a statute should be construed so far as its language permits to be consistent with established rules of international law.
Yes.
And we've given Your Honour at paragraph 40 the reference to the final report by Commissioner Johnston, where the reference where he refers to a paper that the Royal Commission had done, which showed a deep coherence between what he was recommending coroners should do and the principle of international law to which I'm about to refer, Your Honour.
Yes.
Which was quite, with respect, perspicacious, if that's a word. Quite
perspicacious.
Perspicacious for the Commissioner in 1991, because it was very much a developing area, but it's now very well developed. And it's the principle, it's if Your Honour looks at paragraphs 51 and 52 of our written submissions, these are Articles 6 and 2 of the ICCPR. Article 6 is the protection of the right to life. It requires Australia, which because it's a federation includes the states and territories, to protect the right to life, which includes through its agents, including police officers at international law, not either directly harming people or when people are in the care of police looking after them. And then Article 2, which imposes obligations on Australia, those two read together impose on Australia an obligation where a person dies in police custody to hold an effective investigation. And that's set out quite recently only 4 years ago in a general comment by the Human Rights Committee, which we've given, Your Honour. I won't take Your Honour. It's summarised in paragraphs 53 and 54 of the written submissions. And it explains, by reference to a whole lot of decisions by the Human Rights Committee, the content of the obligation. And it coheres in many respects with the recommendations made by Commissioner Johnston, although, of course, this is not concerned with Aboriginal deaths in custody, this is any death in custody. And in that sense, it aligns with the scope of the Coroners Act. Your Honour, the case is the one in footnote 39, R. Morahan and West London Assistant Coroner, 2021, Queen's Bench 1205.
Yes.
And I think it's Lady Justice Popplewell gave this summary, which has since been said to be a very good one, of the different principles which arise, but in subsections, in subparagraph 3, as they're set out, there's an investigative duty to inquire into and explain the circumstances of a death. I'm sorry, I should start at subparagraph 1. There is a negative duty to refrain from taking life without justification. This arises not only at a state level, but more commonly in practice at an operational level, and includes cases where an individual dies at the hands of an agent of the state, such as a police shooting. So that's a sort of more direct duty not to take life. And then subparagraph 3, there is an investigative duty to inquire into and explain the circumstances of a death. As I explained below, there are 2 different investigative duties which have a different scope and different juridical basis. One is a substantive duty to investigate every death as an aspect of the framework duty, and that's just the general obligation of police to go around and investigate and charge people with appropriate crimes and so on. The other is a procedural obligation, which arises only in some cases and is parasitic on the possibility of a breach by a state agent of one of the substantive operational or systems duties. When the latter arises, it is a duty of enhanced investigation to initiate an effective public investigation by an independent official body. And if I could just give Your Honour then some key references there's quite a lengthy but very learned discussion in that decision. At paragraph 70, Her Honour summarised some of the key cases in the UK which show that a coroner's investigation is the key mechanism by which that enhanced investigative duty is carried out. Paragraph 74, I'll just refer Your Honour to paragraph 74, paragraph 77, and I think they're the key ones, but there's a discussion for about 100 paragraphs. So we say that that is a very important obligation of Australia and therefore of the Territory, that it is carried out or implemented by the enactment of the Coroners Act, but the construction of the Act as enacted in 1993, which would allow police officers, who are the very people who have the information, to refuse to give answers, would be inconsistent with that duty, and therefore that supports that first constructional part of our case.
Thank you.
If the court pleases, those are our submissions.
Yes, thank you, Mr. Neckerpin. And now I think that Mr. Bowe, is that?
I think I'm on mute, so am I? Can Your Honour hear me now?
Yes, I can now.
We'll be about 5 minutes, Your Honour. We expect that any oral submissions in relation to the substantive matter before Your Honour will not be of much use. So we're not going to expand on our written submissions on the substantive points. I do want to remove a distraction and withdraw our faulty reliance on Heron at paragraph 12 of our submissions for the reasons indicated by Mr Doyle yesterday. The fault was entirely mine. I had misread it, and despite prompts from at least one of my juniors, it didn't correct it. So I apologise for that. The one point that we wish to take up, Your Honour, is one that just fell for discussion just when Mr Neckerville was submitting as to the relevance of section 79A. I'm mindful that when Mr Gain raised that section with Your Honour yesterday, Your Honour correctly pointed out that that issue is more relevant to the coroner's job in the event that the intervener's interpretation of section 38 is adopted. But may I just persist with one aspect of it, and it's a practical one, and I make it because the family's interest is to get on with the process of assembling the evidence, because it has been quite a long time since the events in question. And we raise it on this point. The two plaintiffs who are seeking the particular declarations are in fact people who are subject to the Police Administration Act and the Section 79A procedure. Our contention is this, that these declarations are completely hypothetical unless there is a real prospect that the privilege against exposure to a disciplinary penalty would actually be available to the plaintiffs. In our submission, the privilege is not available unless the witness's answer would increase their risk of being exposed to such a penalty, and we've got a reference in our submissions to what Justice of Appeal Ashley wrote in Gemmell, and Your Honour will see that in paragraph 14 of our submissions. In the case of the present plaintiffs, as I said, are members of the Northern Territory Police Force and requires consideration now as to whether the declaration sought should be made. That section, that is section 79A, requires a member of the Northern Territory Police Force to answer questions, etc., as Your Honour knows from how that provision works. Now, any answers or information provided can be used against the member in those proceedings. In those circumstances, answering a question before the coroner cannot increase a member's jeopardy of a disciplinary penalty. In the case of Bowens, Sergeant Bowens, he's already been disciplined and he has not sought yet. And bearing in mind, Section 41 directions have not been given, etc. Constable Rolfe, as Your Honour knows from Dr Freckleton's material, has already been through many disciplinary investigations on various topics. So in our submission, Your Honour could take into account that the state of the material before Your Honour is such that the declarations being sought by these plaintiffs are completely hypothetical. Alternatively, and that is why in paragraph 18 of our written submission, we suggested an alternative declaration, because in circumstances where the plaintiffs appear to be proceeding on the basis that they are entitled to claim the privilege, it is appropriate for this court to address the Section 79 issue and consider making the declaration we seek. We're concerned, very concerned, that if the Attorney-General and other interveners' position is in fact accepted by Your Honour, that we are likely to be back before the court because of a disagreement about whether or not these two members can in fact claim the privilege. So that is why, to make sure that we're not wasting more time in this inquest, that Your Honour consider making the declaration that we've drafted in paragraph 18.
The difficulty with that, Mr. Bowe, is that there's not been a full... So the evidence in relation to whether or not these officers would be entitled to claim the privilege in the circumstances simply isn't before me, and really there's no originating process from your clients seeking any such a declaration. It's really... Well, it is really a matter for the coroner to consider, is it not?
It is, of course, and I take into account the procedural difficulties as we've mentioned, but if Your Honour is willing to at least make some comment about that, it may assist the parties to consider the position so that these disruptions, they are entitled to make these applications, don't result in this inquest going off the rails, as it were, with its current timetable, which it already has.
Yes. Yes, thank you for that.
Thank you, Your Honour.
And then, are you going to take the reply, Mr. Doyle?
If I may, Your Honour.
Yes.
Might I just deal first with the very last set of submissions? We would submit that the parties for whom learned friend Mr Bowe appears have not filed any originating process. No. And, Your Honour...
I don't think I need to hear you further on that.
I just was going to say I haven't tendered a whole range of materials that could be relevant to that matter. And
well, it's not really a matter that is properly before this court on this application.
Thank you, Your Honour. Might I make some submissions in response to the Attorney-General's submissions? The learned friend Mr Games said at transcript 67 that coronial proceedings aren't relevantly curial proceedings, and he said in the context of having pleadings, discovery, etc., even though a coroner has to act judicially. The authorities in this area don't, it's true, identify with precision what the defining feature of judicial proceedings is, or what is relevantly a curial context for the purposes of this distinction. We would submit it's not really to do with having pleadings or discovery. Pleadings or discovery are processes that give occasion for a claim of privilege, compulsory processes, but they're not the reason for it. They're really a manifestation of the privilege or the right. Indeed, the analysis in cases such as Pine Board talks about examination on oath as the paradigm case of compulsion, and that is, of course, a feature of an inquest. We would submit that what marks out a proceeding as relevantly curial for these purposes is the involvement of an independent judicial officer who's involved in the administration of justice, not conducting a purely executive function directed towards an executive outcome. As I submitted in chief, the coroner exercises judicial power, is engaged in the administration of justice.
You don't need to repeat those submissions, I think, Mr Doyle.
My learned friend said at transcript 67 that in the case of Bell, it appeared to have been assumed that the proceedings were not curial for the purpose of Justice Blue resolving the case. Respectfully, the opposite is so, and that is clear from paragraphs 149, 150 and 179 of Justice Blue's judgment.
149 to 150, and what was the next
and
one?
179, and the fact that he said he did not need to resolve whether the privilege was available in a non-curial context. He could hardly have said that, but then proceeded to decide the case on the basis that it was non-curial.
Yes, all right, okay.
My learned friend referred to section 39 and said it was obviously important because if one lands on the point that these are not substantial rights but at most rules of evidence, then section 39 does away with it.
Yes.
On no view is penalty privilege merely a rule of evidence. It operates, for example, as a bar to discovery and production. Those are not principles of evidence. They are principles about compulsory process.
Yes.
We'd just give Your Honour a reference to what Justice Gummo said in Propend, 1997, 188 CLR 501.
Was this on a list of authorities, or do I need to write down the...
It's on our list at case 20.
Okay.
At pages 566 and 570, where Justice Gummo said a privilege is to be characterised as a bar to a compulsory process rather than a rule of inadmissibility. My learned friend Ms Edwards said at transcript 77 that Daniels goes as far as unambiguously stating that the principle of legality does not apply to penalty privilege. Respectfully, that takes paragraph 31 of Daniels Corporation too far. What was said there was simply that no decision of the court holds that penalty privilege operates outside judicial proceedings, much less that it's a substantive rule of law. But the mere fact that the court said there was no authority that it was a substantive rule of law doesn't mean the principle of legality isn't engaged, particularly within the context of judicial proceedings. In relation to that, and if I could jump for a moment to my learned friend for Najar's submissions, my learned friend gave Your Honour a reference to an observation of Justice Edelman in a recent case of Shi, S-H-I, 2021, HCA at 98. Could I give Your Honour one authority, which is one of the factors that was referred to by Justice Edelman in She. I'll just show my learned friend, I don't have copies for all of the parties, but it's a decision of the High Court, Mann against Patterson Constructions, 2019, 267 CLR 560.
Thank you.
Your Honour, the context is that the very proposition that my learned friend cites of Justice Edelman at paragraph 98 of She, in the footnote, refers to paragraph 159 of the joint judgment in Mann and Patterson.
Refers to paragraph what?
159.
159.
And if I could ask Your Honour to open that up.
Yes.
Now, this is in the joint judgment of 3 judges who were in the majority. The court said, or the judges said, it, namely the principle of legality, requires a clear indication of intent to conclude that legislation abrogates common law rights, with the required clarity increasing the more that the rights are fundamental or important.
Yes.
Now, that is, as learned friend cites, authority for the notion that it is not a purely monolithic or binary concept, but it is engaged by the abrogation of a common law right. Mm-hmm. It is not necessary that there first be a substantive rule of law or a fundamental common law right before it is engaged. In fact, Your Honour will see the footnote that's given for 2 common law rights, 243, in fact includes a reference to what the plurality said in Pine Board at page 341.
Yes.
It's sufficient then for our purposes to characterise penalty privilege where it operates as a common law right, and as I put in chief, even the full court in Frutignier accepted that it had evolved into a common law right at paragraphs 32, 39 and 47.
Say that again, wait a minute. Say that.
Frutignier 32, 39, 47. It is enough that it is a common law right applicable in judicial proceedings. It is true that were it more fundamental, there might be even more clarity required for its abrogation, but we say it is required to be abrogated and it is not required to be implied. And that, we say, is exactly the approach that Justice Blue took in Bell, and for that reason we respectfully disagree with the submission put by Ms Edwards at transcript 84, which was to the effect that Justice Blue wholly applied the reasoning in Pine Board which had been disapproved in Daniels and Rich. Quite the opposite. He said, I put to one side non-judicial proceedings, but it is a common law right, and I have to see whether it's abrogated. And that is not touched by Daniels or Rich in our respectful submission. Could I turn then to my learned friend's submissions on behalf of Najar. If you'll just give me one moment. My learned friend adopted an approach, as you know, of starting with 1993 and then moving to 2002. And my learned friend said it was the same approach that my client takes. With great respect, we don't suggest that Your Honour must proceed in that fashion. The burden of our submissions was to show that neither as at 1993 nor as at 2002, if one starts with a presumption of a common law right, could it be said to have been abrogated? But
if you start with the presumption of a common law right,
neither reading the Act as
I got that, a common law right, then neither the 1993 Act
nor the
Or
Act as
the amending
amended.
Act abrogates the right, not even section 41.
No. And, Your Honour, because section 41 is picking up the very concept of a judicial examination on oath, which carries with it, we say, an implication of the penalty being available. But I just want to address the very subtle question of the technique of statutory interpretation that my learned friend sought to contend for, which is a purely sequential approach, albeit that it was an unusual sequential approach because it involves taking concepts that we understand now back to 1993, even though they weren't the understanding of the law in 1993, and then testing what the position was in 2002. Some of the difficulties that can arise from that kind of approach were referred to by a bench of 5 judges in a South Australian Supreme Court full court decision of Martin against the Electoral Commissioner, 2017, 127 SASR 362 at paragraphs 218 and 219. That was in a joint judgment of 4 justices of the Supreme Court. The court deprecated an approach of testing whether an assumption was present at different points and looking at the marginal effect of statutes through time. And the court did so by reference to what the High Court had said in Commissioner of Stamps against Telegraph Investment, which is 1995, 184 CLR 453 at 463 and at 479. I won't read the full extract to Your Honour, but I would invite Your Honour to have close regard to it. The proposition is that an amending act is taken to be a reenactment of the whole act, and one construes the whole act as though it is then enacted. One doesn't construe the act incrementally, albeit that history is a relevant contextual factor. And at paragraph 219 of this decision in Martin, reference is made to a decision of Chief Justice Kourakis in a case of Palace Gallery. And I'll just read, Your Honour, a brief statement from it. The legislative history of a statute is an important aid to its construction, but it's an important principle of statutory construction that the meaning of legislation, as enforced from time to time, must be ascertained from the words of its provisions in their current statutory context, and so that the statute operates as a coherent whole. The principle of statutory construction would be subverted if a piecemeal, isolated historical construction were given to each provision. Indeed, at a practical level, the process of construction would become a Herculean task, requiring the clearing of moulds of discarded and superseded legislation accumulated over many years. This principle might assist Your Honour if Your Honour rejects submissions entirely, but is choosing between the Attorney-General's approach.
Backing up the Attorney-General at this point.
Well, it also supports our submissions in this way. We simply say, if one asks the question looking at the Act now, knowing nothing of the history, one starts with the proposition that there is a common law right available in an inquest of penalty privilege, and one asks whether it's been abrogated. We say Section 38 doesn't, because it's concerned with incrimination. The privilege survives. But if Your Honour rejected that, it would be very open to Your Honour to say, well, in deciding whether it's abrogated now, looking at the Act as it stands today, I can take an intermediate course consistent with the principle of legality. I can hold that it is only abrogated to the extent that Section 38 overrides and a certificate comes with it. It is not as complex as my learned friend makes out that process. One can simply say, I need to find that penalty privilege is displaced, and we say Your Honour won't find that, but if Your Honour does, you would find it displaced
Subject
by
to the
38,
certificate, yeah.
and consistent with the principle of legality, one would do the least damage to the privilege, and that would be, in that case, to treat criminate as capturing the privilege. Your Honour, the other propositions of my learned friend largely turn, as Your Honour has observed, on viewing this whole question through the prism of the conduct of police. We respectfully submit that is the wrong prism through which to look at it, and one should, insofar as one's having regard to the provisions of the Police Administration Act, we would respectfully submit they have their own mischief and purpose and they operate on their own terms. And true it is that there are broad powers to direct police to answer questions in connection with discipline, and true it is that various inroads are made in that context into the privilege, but they're made in a designed and careful way. For example, Section 79A, which Your Honour has been taken to, is premised upon there being an allegation or a relevant suspicion of a breach of discipline. It is not a holus bolus removal of the penalty, the privilege, either self-incrimination or penalty privilege. It is a calibrated response where someone within the police force has formed the view that there is a matter warranting investigation. One doesn't work from that to say, well, we need to make sure we can get to that stage, so we must read the Coroner's Act as allowing the uncovering of evidence so as to facilitate police discipline. In my respectful submission, that is to expand on the careful limits of the Police Administration Act and then throw them into another act and allow them to drive the meaning of it, we say illegitimately. Your Honour, I just want to, my learned friend mentioned the case of R against IBAC. I just want to very briefly say something about that. It was a very different case because the legislation that established the forum in which the question of whether someone could be examined on oath was taken had as one of its own purposes dealing with the probity of the conduct of police. That emerges from paragraph 51 of the judgment in IBAC. In other words, a little bit like my submission about the Trade Practices Act, the very purpose of the legislation in IBAC involved investigating into corrupt conduct by police. It was hardly surprising, I'd say with respect to those who argued otherwise, unsuccessfully, that not only that in those circumstances the High Court didn't extend the companion principle in X7, and that's really the ground upon which the appellant lost in R and IBAC, because what was being contended for was not just the X7 rule that you can't be examined on oath once you've been charged, but rather an extension that you can't be examined on oath once it's suspected that you've committed an offence or that it's on the cards that you're going to be charged. And so the short ground of the disposition of that case was that X7 should not be extended in that way. And the icing on the cake was, well, if it was, then that would render the whole scheme incoherent, because the whole question is, has there been misconduct by parties including police, and police are specifically mentioned in the Act? That would be frustrated if the X7 companion principle were to reach back further in time. Your Honour, I might just make one further submission about the stultification argument put by my learned friend, and also put by Dr. Freckleton. The argument being, and this has been put, I think, also by the attorney, that if my client's construction is right, you can be compelled to incriminate yourself, but you cannot be compelled to expose yourself to a penalty.
Yes.
That's a particularly stark way of putting the proposition, but a more nuanced way of putting the proposition is to recognise that you very well may not be compelled to incriminate yourself, depending on how Section 38 plays out in practice. And in cases where there is a factual overlap between
incrimination and penalty, there may be an issue about whether, because it's likely that the criminal offence will have gone first in being dealt with for McMahon and Gould type reasons, there may be a very live question about whether there remains an appreciable risk of a penalty, having regard, for example, to time limits that might attend those issues. And that might mean that a claim of penalty privilege is in fact not available, or it might be that the claim isn't taken.
All that submission amounts to is that it wouldn't always be absurd, isn't it?
My point is, because it isn't that black and white, the position is not absurd.
Okay.
And it is not sufficient for even allowing that the principle of legality is not binary or monolithic. When it's engaged, it's not sufficient to say, well, for many of the reasons that there's been an inroad into penalty privilege, it would work better, or as Mr. Game put it, work really well if it also covered penalty privilege. Maybe. That's perhaps a contestable policy question. But the question is, has that been done? Not should it be done?
Yeah.
Your Honour, I think I don't need to say anything specific in response to Dr. Freckleton's submissions, except to say two things. One, he referred to penalty privilege as an accepted common law right, consistently valued, and we very much rely on that in light of what's said in Mann and Patterson. But we do differ from a learned friend in his submission that what Justice Kirby said in Rich at 129 can be taken to be a current statement of the law on the question of penalty privilege. He dissented in Rich, and it's that's sufficient to show that he took a very different view of the operation of the privilege. Your Honour, without wishing to suggest that Mr. Boyle will comment on the question of international law, I arranged with him that if any replies to be made on that topic, he would make that reply. So unless Your Honour has further questions, those are my submissions.
Thank you, Mr. Doyle. Mr. Boyle, do you have anything to say in reply in relation to the international law aspect of it?
I do, Your Honour. But before I come to that, the first thing I just wanted to say is that we would obviously embrace what's already fallen from Mr. Doyle in terms of reply more generally. And I think this has already been remarked upon by others, including Your Honour, but in our submission, Section 79A is irrelevant to the construction of the Coroner's Act. And if you were to have any regard to that, it would be to really let the tail wag the dog. Coming to the international law submissions made on behalf of NAJA, the first point to be made is that insofar as one constructs this notion of effectiveness and the need for an effective response to deaths and their investigation, well, it's a bit like the submission I put to Your Honour yesterday, which is effectively that effectiveness doesn't entail the pursuit at all costs of this investigation process. And so we say that, in effect, the constructional principle isn't engaged because it's not inconsistent with international law to construe the act as we're contending. And in effect, one can readily say whether penalty privilege is available to be invoked or not. The system which is otherwise put in place by the Act is effective and discharges the obligation insofar as Australia's international obligations go. The next point to be made in response to the submission on behalf of NAJA is that in any event, there's a contest here between competing rights. Indeed, effectively, the right to silence is itself recognised in Article 14.3G of the ICCPR, which is the same document treaty which gives rise to this right to life on which reliance is placed. And in that regard, I don't think Your Honour has a copy as far as I'm aware, but I can read to Your Honour what that provides. It says, in determination of any criminal charges against him, everyone shall be entitled to the following minimum guarantees in full equality. And it says, G, not to be compelled to testify against himself or to confess guilt. So we say that there is, in fact, some competing right which otherwise arises here. And then the question becomes, how do you reconcile those competing rights? The cases indicate that obviously international treaty obligations have to yield to the statutory text. And we say that effectively the attempt to invoke Article 2 here doesn't assist our friends in their contended construction of the Coroner's Act. The final point to be made is that there's a contention made at paragraph 57 of NAJA's submissions about the need for the territory and other organs to comply with treaty obligations. And I wanted to give Your Honour a reference to what was said by Justice McHugh in Al-Kateb and Goodwin. And this is not on anyone's list, so I'll give Your Honour the reference.
Yes, please, if you could spell it for me too, please.
Yes, it's Al-Kateb, A-L-K-A-T-E-B,
Yes.
and Goodwin, G-O-O-D-W-I-N, and it's 2004, 219 CLR 562. And the paragraphs that I wanted to take Your Honour to are at 63 to 65. And what is said there by His Honour, Justice McHugh, is that the rule of construction in question is based on a fiction. He says in paragraph 63, gone are the days when the rules of international law were to be found in the writings of a few well-known jurists. And then going on to paragraph 65, His Honour notes that in Minister for Immigration and Ethnic Affairs and TO, counsel for the minister told this court that Australia was a party to about 900 treaties. And then His Honour says, when one adds to the rules contained in those treaties the general principles of law recognised by civilised nations and the rules derived from international custom, it becomes obvious that the rationale for the rule that a statute contains an implication that it should be construed to conform with international law bears no relationship to the reality of the modern legislative process. And so whilst we accept that it is a rule, we say in circumstances where, in effect, we say nothing actually turns upon it, there's an air of unreality to the submission that Your Honour would construe the Coroner's Act as though penalty privilege never applied by reason of Australia's obligations under the ICCPR in respect of the right to life. We just say that's a very long bow that's being drawn on behalf of NAJA, and there's no need for Your Honour to adopt such a construction by reason of that principle of statutory construction.
That's not the only reason that they say there was never a penalty privilege available under the Coroner's Act, though, is it?
I appreciate that, Your Honour, and that's already been responded to by Mr Doyle. And
yes.
So I'm simply saying it doesn't add anything to the picture in my submission to seek to invoke international law.
Yes, I follow that.
And then I think I'd said that was the final point, but I've overlooked that there was one other point which I wanted to make, which was simply that the case that's referred to in their submissions in the Court of Appeal in the United Kingdom was a case that was obviously concerned with the European Convention. It may be that as I said, that it's effectively the same provisions in that convention which NAJAR relies on under the International Convention on Civil and Political Rights in this case. However, the observations which are being made there and everything that effectively underpins the reasoning of in that decision is really a reflection of that context that exists in the United Kingdom where, up until relatively recently, they were bound by the European Convention and the obligations that flowed from that. And that jurisprudence is necessarily coloured by that context.
Yes.
And it wouldn't assist Your Honour to effectively pick up and apply those principles here, holus bolus.
No, point well taken.
And unless there's anything further, Your Honour, those are my submissions in reply.
No, thank you very much, Mr. Boyle. Now, I need to, there's an ongoing inquest, so there's some urgency for a decision.
Well, I think in that regard, Your Honour,
Yes.
there is also, and I don't have the precise terms in front of me, but I think that there was an injunction that had been granted by Her Honour Justice Brownhill previously, which I'm not sure whether that's now on its terms expired or not.
I think it was extended until close of business today, my recollection is that right?
Your Honour, I wonder if you'd be assisted by Mr Officer who appears in the inquest, just telling Your Honour where things are at.
Yes, please.
Yes, Your Honour. At the moment, there is an injunction in relation to the first plaintiff, Mr Bowens. Constable Rolfe has been stood down from any further evidence until this court decides the issues before it. In terms of scheduling, the inquest is due to wrap up by next Friday for this year and then resume 23rd of February next year for 2 weeks, but could possibly be longer, in fact, most likely longer, if that assists.
So that cuts down on the urgency. I mean, I will endeavour to... the reason I was asking is that it may be that I can announce a decision before the written reasons are finalised, if that would assist. I should be able to have written reasons prepared within a fortnight. So,
we would ask that Your Honour take that course, even though it would only take you a fortnight, that you do announce your ruling first and provide the reasons later.
well, I might not... I'm not sure that there is a great deal of utility in that if the inquest is not resuming until the 23rd of February.
That's right, Your Honour. And we would prefer written reasons, Your Honour.
Yes.
May I raise this?
Yes, Mr Bowe?
Mr Rolfe was to give evidence a week or so ago. I know that, and Counsel Assistant who's appearing at the bar table may well be able to confirm this, it was hoped that if Your Honour were able to give a ruling this week, that Constable Rolfe would be expedited and brought on next week. So that's still a possibility for the inquest in order to achieve what it had programmed.
I don't think I will be in a position to do that this week.
Understand.
Thank you. No, well, I think what I will do is reserve my decision, and I will endeavour to have that decision and the written reasons therefore delivered within 2 weeks. And I do thank all counsel for your invaluable assistance in this matter. Thank you. Please adjourn the court.
The court now stands adjourned.
What do you think? Is it too tight?